friends, today we are going to discuss two very important rulings coming from Hon'ble Calcutta High Court and Hon'ble Jharkhand High Court. Both these rulings are very important and relevant considering the scenario wherein the department is issuing various notices ASMT 10, DRC 01, left, right and center based on differences of GSTR 2A versus 3B, 1 versus 3B, suppliers being non-existent and the registration of supplier being cancelled on a retrospective basis. All such notices are being received by the taxpayers, and these rulings will come as a spot, as a place to take shelter upon, and would benefit a large number of taxpayers. So let's discuss both these rulings and how they shall be beneficial for each one of you. Let's start. The first ruling has come in the matter of Gargo Traders from Hon'ble Calcutta High Court. So let's first understand the facts of the case. So Gargo Traders is a registered taxable person. He has purchased certain goods from a supplier which are received by Gargo Traders. He has in his possession the tax invoice issued by the supplier, the e-way bill and transportation documents reflecting the movement and receipt of goods by Gargo Traders, the bank statement reflecting the payments made to the supplier along with the GST amount. So he has got all these supporting documents with him, and he has claimed the input tax credit on the strength of these documents which are in satisfaction of conditions laid down under section 16 subsection 2 of GST Act. उसने गार्गो ट्रेडर्स ने ये भी चेक किया कि जो सप्लायर का रजिस्ट्रेशन है जीएसटी रजिस्ट्रेशन दैट वाज एक्टिव एट द टाइम ऑफ परचेज ऑफ गुड्स से इन नवंबर 2018, और उसने वो आईटीसी क्लेम किया और उसका रिफंड फाइल किया डिपार्टमेंट के साथ. बट से आफ्टर 2 years डिपार्टमेंट डिस्कवर्ड दैट द सप्लायर इज ए non-existent entity, and the bank account the supplier has opened was based on certain fake documents. And based on this finding, the department proceeded to deny the benefit of ITC in the hands of Gargo Traders. So department ने जो supplier का GST registration था वो retrospectively cancel कर दिया effective October 2018. So before the date of purchase by the Gargo Traders, the supplier's registration got cancelled. And based on this premise, the department said that Gargo Traders need to reverse the ITC claim because the supplier in question is non-existent and is a fake entity, and thus the claim of ITC is not allowed. और department ने कहा कि since registration is already cancelled with retrospective effect and the supplier has agreed for it, then Gargo Traders need to रिवर्स द आईटीसी. उसके बाद गार्गो ट्रेडर्स ने हाई कोर्ट को अप्रोच किया. देन गार्गो ट्रेडर्स फाइल्ड अपील बिफोर द अपेलेट अथॉरिटी एंड द सेम वाज डिसमिस्ड बाय द अपेलेट अथॉरिटी, एंड देन द गार्गो ट्रेडर्स अप्रोच्ड ऑनरेबल हाई कोर्ट थ्रू रिट जुरिसडिक्शन. एंड दैट हाई कोर्ट, आफ्टर गोइंग थ्रू ऑल द फैक्ट्स ऑफ द केस, concluded that the department has passed the order solely based on the fact that GST registration of the supplier has been cancelled with retrospective effect. Department has failed to verify the relevant documents confirming the purchase of goods, the receipt of goods made by the Gargo Traders, the recipient, the buyer. डिपार्टमेंट ने कुछ चेक ही नहीं किया. वो खाली इसी प्रमाइस पे उसने केस बनाया कि सिंस द सप्लायर्स रजिस्ट्रेशन हैज ऑलरेडी बीन कैंसिल्ड विद रेट्रोस्पेक्टिव इफेक्ट, द आईटीसी क्लेम इज नॉट अवेलेबल. हाई कोर्ट ने बोला यू फर्स्ट नीड टू वेरीफाई द डॉक्यूमेंट्स सबमिटेड बाय द पिटिशनर एंड देन पास ए स्पीकिंग ऑर्डर, रीजनड ऑर्डर stating the reasons why this ITC claim should be denied even after production of all the documents, even after satisfaction of conditions laid down under section 16(2) of GST Act. So हाई कोर्ट ने डिपार्टमेंटल ऑर्डर्स को सेट असाइड कर दिया और वापस उनको असेसमेंट या एडजुडिकेशन री एडजुडिकेशन करने के लिए इंस्ट्रक्ट किया। सो ये जो रूलिंग है, it has in this particular ruling, High Court has followed the earlier judgment of Hon'ble Calcutta High Court itself in the matter of LGW Industries Limited, wherein it has been said that the department need to verify whether the buyer and the supplier were in collusion, whether they were hand in gloves in the transaction, and then only proceed to deny the claim. And they need to differentiate between a genuine buyer and supplier. So in case a buyer is genuine, he has actually received the goods and there is documentary evidence proving that, then that case need to be differentiated, and the department should not just proceed to recover the ITC amount from the buyer, because it appears to be a simpler thing to collect the tax from the buyer. So this is a very welcome ruling coming from Calcutta High Court in the matter of Gargo Traders. The second ruling has come from Hon'ble Jharkhand High Court in the matter of Shree Ram Agrotech. इस particular case में जो petitioner है, he received a recovery notice on the strength of a summary order in form DRC 07. On receipt of that recovery notice, the petitioner approached the department seeking the notices and orders passed before this recovery notice. However, the department failed to issue any document, and thereafter the petitioner approached the first appellate authority, Joint Commissioner Appeals. However, the Joint Commissioner Appeals dismissed the appeal based on technical grounds like non-attending the hearing and non-submission of adjudication orders, etc., and did not went into the merits of the case. Thereafter, the petitioner approached Hon'ble High Court under writ jurisdiction. Petitioner ने contend किया before High Court that department has failed to follow the procedure prescribed under GST Act and rules. As per Section 73 subsection 1 and Rule 142, department was obliged to issue a summary notice and a detailed notice reflecting the various grounds and reasons. Against that, the petitioner should have the opportunity to reply that back, and the department thereafter, considering the submissions made by the petitioner, was supposed to issue a show cause notice. And thereafter, under Section 73 subsection 9, before proceeding with the recovery proceeding, department has to adjudicate the matter and pass a adjudication order. However, this entire process has not been followed and there is no document in the records of the department. So High Court, after going through all the facts of the matter, ruled basically setting aside the recovery proceedings, the initial orders, and the orders passed by Joint Commissioner Appeals, and department gave the liberty to the department to restart the proceedings in compliance with the GST Act and rules. Further, the High Court came down heavily on the first appellate authority for not considering the grounds of appeal and passing a speaking order considering the merits of the case, because these were the grounds stated in the appeal itself. And while passing the order, an appellate authority has to consider all the grounds and then pass a order, and it should not be a mechanical and technical order taking the technical grounds. This particular ruling from the High Court and again has reiterated the importance of following the process laid down under the law. Under law, in case a thing has to be done in a certain way, then that has to be done in that way itself and in no other way. So in case that particular process has not been followed by the department, then the whole proceedings will become void as correctly done by Hon'ble High Court in this particular matter. So department need to be careful and should respect and follow the processes laid down under the GST Act and rules, and the taxpayers need to be vigilant to seek their rights as granted under the GST Act rules, etc. So I hope both these rulings would be beneficial for you, and looking forward to your feedback and suggestions. Stay tuned for more updates. Thank you very much.